The phrase form and substance is commonly used in common law countries, but is generally understood in the context of tax planning and tax avoidance. A Danish colleague of the former generation used to refer to this issue as the eternal question in tax law, and it's certainly also a universal issue in tax law, in the sense that all countries with such taxes has to deal with it in one way or the other. In recent years, the international aspects have increased in importance, the main question being to what extent domestic anti-avoidance rules are applicable in cases of when a tax treaty applies. Generally, tax planning is considered not only legal but legitimate, at least until now. However, in most jurisdictions, a borderline for acceptable tax planning has to be drawn somewhere. And if that borderline is superseded, then it means that the transaction will not have the desired tax effects. However, from a private law point of view, the transaction will normally still be valid. And I think generally it's also the rule that even if, for instance, the income tax question is decided on the basis of the substance of the transaction, that is not decisive for other taxes. For instance, if it is an inheritance tax question based on the same facts. The fact that the transaction is considered as tax avoidance does not alone mean that it is a criminal offense. In fact, in most jurisdictions, that is not the case. This issue should be considered in the context of the development of aggressive tax planning, in some countries referred to as tax shelter industry. The tax authorities need instruments to stand up against this. This is important not only for the defense of the tax revenue, but perhaps in the long run, even more for the common taxpayers' trust in the system. The common taxpayers, without similar tax planning options, may be demoralized if it is considered to be too easy for well-off people to get around their tax liability. At the same time, the use of tax avoidance rules challenge principles of the rule of law, not least the ability for taxpayers to foresee their legal status, and, if they are not properly designed, may deter taxpayers from entering into commercially sound transactions. So finding the right balance here is a great challenge for legislators and courts. The issue of tax avoidance should be separated from neighboring issues. First, the finding of the real facts of the case is governed by the rules of evidence in procedural law and not by anti-avoidance norms. Applying a GAR typically does not mean to deviate from the real facts of the case. It's sometimes said that applying a GAR means that the assessment is not based on the facts of the case but on fictions. As regards real facts, this is generally, in my view, not correct. In an inheritance tax case in Norway some years ago, the taxpayer argued that the assessment was based not on the real time of the death of the deceased, but on a fictitious date. The Supreme Court found that that was not the case, but said that the real facts, such as the time of the death of a person, could not be set aside on the basis of a GAR. Next, tax avoidance must be separated from tax evasion, which are cases where the taxpayer produce false or incomplete information to the tax authorities. In most jurisdictions, this will amount to a criminal offense, and the taxation shall, of course, be carried out on the basis of the correct information when it is revealed. Tax evasion is about providing the information. Tax avoidance is about assessing this information when applying the tax rules. An important subgroup of tax evasion is sham transactions or pro forma. That is, in cases where the parties to a contract proclaim externally that the contract has a special private law content, whereas between the parties the content is different. For instance, A and B declares, also to the tax authorities, that A has sold his shares to B, But between A and B, it's clear that A is still the owner. The tax assessment in such cases, I think is the universal rule, shall be based on the real and not the simulated facts. One should here be aware of that in US terminology, the expression economic sham is often used for one of the tax avoidance doctrines. So the terminology here may be a little confusing. Further, tax avoidance should be separated from cases where it is a dispute of the proper private law characterization of a transaction. Tax authorities may typically find a discrepancy between the taxpayer's characterization of a transaction and what would follow from an analysis of the rights and obligations of the contract. For instance, the taxpayer claims that the contract is a lease, but the authorities find that it is a sale. This is part of the general application of tax rules by the tax authorities, and in my view, no anti-avoidance rule is needed for that purpose. The need for anti-avoidance rule may arise if the tax authorities want to go beyond this, typically by recharacterizing the transaction for tax purposes. For instance, under private law, there is a lease, but for tax purposes, the transaction is recharacterized to a sale. Or a share capital gain is recharacterized to a dividend distribution. Finally, the issue of substance over form should be separated from transfer pricing, even if also transfer pricing may be the result of tax planning, of course. Both the conditions and the legal effects differ between transfer pricing rules and GARs. And also the OECD commentaries treats them differently. However, tax avoidance may appear as a preliminary issue in transfer pricing cases, as a question of so-called structural adjustments. That means cases where the controlled transaction is not accepted as it is structured by the parties because its substance differs substantially from its form, or it differs substantially from the way it would have been structured by independent enterprises. In order to combat excessive tax planning, most countries have introduced statutory